All right, so thank you for your patience, everyone. So hello and welcome to another episode of the ICC Academy COVID-19 Briefing, an interactive video series where we explore the economic and health implications of this coronavirus pandemic and what must be done to ensure a successful recovery for businesses big and small. I'm one of your hosts, Thomas Paris, and in this episode, we will discuss how force majeure contract clauses may provide relief during pandemic-related disruptions. Our special guests today include Erdem, Chair of the ICC Commercial Law and Practice Mission, Abhinav Bhusan, Director for South Asia at ICC Arbitration and ADR. And also going to be moderating with me is going to be Angelika Zoder, expert in international contract law at ICC Austria. So these briefings will kick off a collaboration between the ICC, the United Nations, and the World Health Organization. During the session, we will start by running through a few topics, followed by an audience Q&A session near the end. So we invite everyone to send your questions through the chat, and we'll go through them together. Now, there are going to be a lot of you, so please bear with us for us to be able to parse through some of the questions. Both Angelika and I will be highlighting some of them for you. So if you don't have any questions, please refrain from using the chat too much because it's going to make identifying some questions a little bit more difficult, but we'll cross that bridge when we get to it. So let's kick things off. Angelika, the floor is yours.
Thank you, Thomas. It's a pleasure to be here. My task as a moderator is now to introduce both speakers to you, and it's a pleasure and a distinction for me to introduce, first of all, Professor Ercument Erdem. He is not only senior partner and founder of Erdem and Erdem Law Office in Istanbul, Turkey, but he's also an outstanding arbitrator with a long experience. He's the chair of the Commission for Commercial Law and Practice with the ICC. And last but not least, he's professor for commercial law. And together with that, he's very experienced in arbitration, in international commercial law, in antitrust and competition law, in mergers and acquisitions. And he is also arbitrator, sole arbitrator, also, and party-appointed arbitrator with a long-lasting experience. With ICC arbitration, of course, with Swiss arbitration, with Moscow arbitration, with Untitled arbitration. So you can see you will have a very experienced partner here with us. And second, Abhinav Bhusan. Welcome, Abhi. It's a pleasure to have you here too. He's the regional director for South Asia from ICC Singapore, ICC Arbitration and ADR, and ICC International Court of Arbitration in Singapore. Abhi is presently not in Singapore, but is joining us from New Delhi. Thank you. We all do hope that the technique will work perfectly through this session. In case there are any interruptions, please forgive us. We will do our best and join in again immediately. Abhi has a very clear focus in his work as a director for South Asia. He's helping companies, investors, and attorneys in the region to understand how they can efficiently resolve international commercial disputes by raising the awareness on ICA's dispute resolution services. Prior to this, he was regional director. Prior to being regional director at the court, he is the first Indian director, not only, was also the first Indian deputy counsel of the court. And he is our expert on common law jurisdictions. In particular, he was working with parties from the UK, from India, from Singapore, and other regions in Asia. And last but not least, he has contributed to various publications on international arbitration and Indian arbitration law. So I think we do have two very experienced speakers today who will lead you to these sessions. Why are we doing this today? You know, a bit more than 3.5 years ago, the Commission for Commercial Law and Practice of the ICC decided that we would do an update of the Force Majeure Clause. And we will not only do an update from 2003, but we would also include a shorter version, and we will update also the Hardship Clause. And that's what we are talking today. This Force Majeure Clause was published recently in Paris a few weeks ago. And when we started with the work on this update, no one of us could foresee what would happen right now. And not even in my wildest dreams, I would have thought of a pandemic with such a global effect, but that's the situation we are right now in. And that is the reason why we're discussing this new ICC publication today. A force majeure clause has a certain function within a contract. Usually in every contract, there's a clear principle, at least in the civil law countries, and a bit different in the common law countries. It says pacta sunt servanda. If you have signed a contract, you have to stick to it. You have to fulfill your contractual obligations. That's the main focus of a contract. And now the force majeure clause provides for the case where there's an extraordinary event and one of the parties, or in this situation, maybe even both of the contractual parties, are prevented from fulfilling their contractual obligations. And we are discussing now what's a force majeure event and what might be the consequences. So I will turn now to Ercument and ask you, could you please give us a short introduction into the concept of force majeure and explain it a little bit?
Thank you, Angelika. It's a pleasure for me to be with all the participants and you. And I'm very glad to present the ICC new force majeure clause as well. So as you have rightly stated, the rule is to respect to the contracts and to perform them. But sometimes there are impediments which are beyond your control and which prevent you to perform. These events, these impediments are generally known as force majeure events. So the concept of force majeure is recognized worldwide. However, each particular national laws have different regime for that and may differ from country to country. So what is important is what you have in your contract, how you drafted or a force majeure clause in your contract, or if you don't have any, what the applicable law says with respect of the force majeure event. And this is why to draft a reliable force majeure clause is very important, since the applicable law may differ substantially. So priority to the contracts, and please check your contracts. What are the requirements? What are the formalities? What you have provided as consequences of the force majeure, suspension of the performance of the obligations, termination, if termination, when, how. These are all the questions that you have to address in your force majeure clause, hopefully. But ICC force majeure clause will address all of them as well. So I'm gonna point it out, this novelty, in a few seconds.
Okay, so you can draft your own force majeure clause, but you don't have to reinvent the wheel again. You can also use the ICC force majeure clause, either in the long or in the short version. So could you please advise if there are any additional requirements and describe the contractual consequences a little bit?
Yes, perhaps I can continue with the ICC clauses in that respect. Before to do that, I would like to point out, in your contracts, under the freedom of the contract, you can provide anything you want. You can provide many requirements. You can provide, for example, a notice requirement that in the case of occurrence of an impediment which prevents you to perform your contracts, you have to give a notice. You may require a certification of these impediments from local authorities or from governmental agency and so on. So ICC will deal only with one of these general requirements that we usually see under the contracts, the notice requirement, but not the certification requirement.
Mm-hmm. Yeah. And could you please go a bit into the detail of the model ICC force majeure clause, especially the new one, 2020, but also compare them with the 2003 version, because I'm quite sure our participants who are listening right now, and if they have used the ICC force majeure clause in their contracts, it must be the 2003 version, because the 2020 has been published, I think, 2 or 3 weeks ago. So for all ongoing contracts, it will be the older version. Would you please outline this a bit?
Yes, true. Yes, true. ICC drafted ICC Force Majeure Clause and Hardship Clause since very long time. The current version, or before this current version of 2020, the existing version was ICC Force Majeure Clause and Hardship Clause 23. So it is still in force, and I'm sure that most of the participants may refer to this clause in their contract. If it is the case, so you may invoke the ICC Force Majeure Clause or Hardship Clause that you put in your contract. I have to warn the audience that these clauses are not automatically applicable. These are part of the soft law, and they become contractual provisions once you refer them in your contract. So this is important that you refer them into the contract. This 2003 clause follows the system of the CISG. So the CISG, as you know, is the United Nations Convention on Contract for International Sales of Goods, and provides 3 criteria. There should be an impediment beyond the reasonable control of the parties. This impediment should not be foreseeable at the time of the conclusion of the contract, and the effects of the impediment cannot be avoided or overcome. The 2003 version provides that all these 3 conditions should be met together in order to be qualified as an event of force majeure. But the same rules provide a list of events, and this list of events, in fact, are the presumed events. Why they are presumed? If any events is in this list, we presume that it's unforeseeable and it's beyond the control of the party. So the only remaining condition that should be fulfilled is the affected party has to prove that it cannot overcome the consequences of this impediment. What is important with respect of the requirement is the notice. The 2003 rules provide that a notice should be given without delay once an impediment occurs and prevents you from the performance of the contract. Why the notice requirement is important? Because all the relief is subject or is conditional to giving such a notice. What are the effects of such an impediment of a force majeure event? The suspension of the performance and the relief from the breach of the contract and the losses. Because in the case of a force majeure, you cannot perform your contract. Non-performance means a breach of the contract. However, it's due because of an event that prevents you and which is not under your control. So you are relieved from the breach, and consequently you are relieved from the losses deriving from this breach of the contract. How long you have to be in that position? How long you have to live with this impediment? Can you terminate the contract? How? When? The 2003 doesn't give you any precise time frame. It says only that if the parties are deprived from what they have expected from the contract, if the performance of the contract doesn't mean anything for the parties, then they can terminate the contract. While you have the right to terminate the contract, you have to take all reasonable measures in order to mitigate the losses. So the new rules, the 2020, follow the same structure. So you may ask why we need these new rules, why ICC Force Majeure and Hardship Clause 2020. As you have rightly stated, the need comes from the request of the SMEs. SMEs requested a user-friendly, shorter, and much more comprehensible version of the ICC Force Majeure Clause. So this was the starting point of the drafting process. Now, the 2020 will be applied only when you refer in your contract. So we cannot apply them to this current situation, but it is very relevant for the future contracts. And I think it's well-balanced, reliable, and user-friendly model for all the SMEs. And it could be used as a checklist for bigger enterprises. We'll have two versions, the long version and the short version. The long version could be referring your contract, and the short version is only 3 paragraphs. You can incorporate directly in your contract. But for the short version, I have to remind something. As the name suggests, it's the short version. It doesn't cover all the aspects. So mitigation, third-party non-performance, unjust enrichment. These are the topics that are not elaborated in the short version. But in general, this new clause follows ICC Force Majeure Clause 2003. What are the novelties? The novelties are, we provide a definition of force majeure. We added some headings for the articles. We made a separate article for the notice because in 2003 version, the notice requirement has divided into several articles. Now we have a particular article for that. And the presumed force majeure event are simplified but enlarged. Just for simplicity reasons, we sum up some of the events, but we added some more. For example, currency and trade restrictions, embargo, sanctions. For sure, under the principle of freedom of contracts, you are free to add or to delete some of the event in accordance with the specific of your contract or of your industry. The big novelty is with the right to terminate the contract. The 2003 doesn't provide any time frame. The drafting group thought that to give a time frame will provide more foreseeability and more certainty. This is why the new rule provides 120 days. If the impediment exceeds 120 days, each party may terminate the contract. Angelika?
Yeah, that's quite clear. The questions I'm regularly confronted with, and usually as well, is, well, the corporates, the companies do call us and say, we do have a pandemic now. Is this a force majeure event? Can I raise it in my contract? And there's a typical answer that I usually give, and I think you will do the same. I say first, it depends. Depends, check your contract, check your clause, check the applicable law. And I have to confess that, of course, what we have now with COVID-19 is an extreme situation, but it's not the case that every trade has stopped yet. Some things do work, and some trade goes on. Just think of the medical equipment and so on. So it's not, the declaration of COVID-19 as a pandemic does not automatically mean that every contract and each project is subject to force majeure event. That's not the case, but it will be in many cases. But what I would also like to raise a little bit, and it's also included in the force majeure clauses, but it's not that prominent, is in many cases it might not automatically be force majeure, but it could be hardship. And I would you like to say a few words on the hardship clause? Because I think it's also worth mentioning it. Some people may have incorporated it in their contracts, and it could be a solution in case your contract doesn't provide for force majeure, but maybe hardship could be the solution for you.
Exactly. Thank you. As you rightly stated, the COVID-19 as a plague or epidemic is a listed event, both in 2003 and 2020 versions. But it doesn't mean as a listed event that it automatically becomes a force majeure, but it is a presumed event. But don't forget that you have to prove as the affected party that you cannot overcome its consequences. So let's assume that all your employees are infected, or the premises are closed by order of the authorities, and you cannot perform your contract, and there is no other way to overcome the effects. In that case, we may say that COVID-19 is an event of force majeure. Okay. The same applies for 2020, obviously, for future contract. As regard to the hardship, so the 2020 and 23 has a very similar hardship clauses. But the big difference with respect of the 2020, that it provides a different solution in the case of hardship. So we all know that in the case of hardship, there is an impediment, like in the case of a force majeure, but this impediment does not prevent you to perform your contract. It does render more burdensome. So you can still perform, but it will be more burdensome for you. So what 2003 provides as a solution, it says you have to negotiate the contract again. But if your negotiations will not go into the right direction, you cannot agree, and you cannot create again the balance of the contract, in that case, the affected party may terminate. So the 2003 version provides as a solution, first, renegotiation of the contract, second, termination by the affected party. Since 2003, there are a lot of development in this field. Many national laws adapted new rules and provides an adaptation provisions. So the drafting group would like to reflect this development in 2020 and provide 3 optional solutions, 3A, 3B, and 3C. For the participant, you can find the clauses in the room. I guess it's ready to be downloaded by the participant. So if you're going to look at 2020 hardship clause, 3A, 3B, 3C, and 3A is identical with 2003. The affected party may terminate. 3B, it's to the judge to adapt or terminate. So the party may seek the assistance of a judge for termination or for the adaptation. This is the novelty. The 3C, the last option, is the judge to terminate, because sometimes the party may say, okay, but if we're going to leave to the discretion of the party to terminate the contract, it can be misused. So let's leave it option for a judge or for an arbitrator, and it decide to terminate the contract. So this is the novelty for the 2020 version of the hardship clauses.
Thank you so much. Any last comment before we go to the next speaker?
Perhaps I have these 5 priorities or a list of to-do in the case when we have this impediment. The first one, check your contract. Do you have any force majeure clause? And if you have any force majeure clause, check whether plague epidemic is a listed event, because under the freedom of contract, you may list or you may not. If you don't have any clause, it means that you are at the mercy of the applicable law. So check what the applicable law provides, and it's better to have an assistance of a legal expert. Fourth, once you have a clause in your contract, follow all these requirements, notice, evidence, etc. And 5, mitigate the losses and ready to reimburse what you have already taken in the case of termination. Angelika?
Thank you so much, Ercument. The last word, mitigate the losses, leads us to our second speaker, because there will be losses. In the current situation, it's obvious that international trade goes back. Many contracts will not be fulfilled because it's simply not possible. And obviously, there will be different opinions on which party will have to pay damages, for example, or which part will have to bear these losses. And that leads me to you, Abhinav, because you're the expert for the dispute resolution in ICC. Should I choose to contest my claim, or how do I assert a legal claim in a COVID-19 situation? What are the options if I'm a party to a contract and I can't fulfill it, or the other party can't fulfill it? What are the options?
Thank you, Angelika. It's a pleasure to be here, close to New Delhi, which is why I keep going. My visuals keep going because I'm at my little town in Saharanpur, Uttar Pradesh. So I will still be audible. Coming back to your question, as Erdem said, the first thing first, look at your contract. Look at your contract, whether it has an FM clause. If there isn't one, then look for something else. If there's nothing, then look at the governing law. Now, when you have to contest your claim, the second most important thing is you have to look at your contract again. Only this time, you're looking at the dispute resolution clause. See if you have a dispute resolution clause in your contract. What does it say? Does it speak about court litigation? Does it have a mention of arbitration in it? What kind of arbitration does it mention? Does it mention an ad hoc arbitration? Does it mention an institutional arbitration? If mentions an institutional arbitration, then see which institution does the clause mention. Assuming it is ICC arbitration, which I very much hope it is, if should this go through, then of course consult your lawyers. Now, all things considered, what is the core issue here? The core issue here is that the parties, the contract negotiators, the judges, the courts, the arbitrators would have to find a fair compromise between the principle of what you had earlier mentioned and Erdem had earlier mentioned of pacta sunt servanda, which is, as you all know, is a Latin term and means that the agreement must be kept. The sanctity of what the parties have agreed to must be adhered to. So it's a compromise between pacta sunt servanda and the need to take into account unforeseen circumstances which make performance impossible or too onerous. Particularly in international commercial transactions, the result in the vast majority of cases is likely to be what is mentioned in your FM, the Force Majeure Clause, and not the applicable law, which will regulate the legal consequences of events beyond the risk and control of the parties. So look at your contract, look at your dispute resolution clause, see what it says.
Okay. And it leads me to my second question. Is COVID-19, as we have it now, an arbitrable situation? And what are the different options available to resolve the dispute? Is mediation maybe possible or recommendable even?
Yes, I mean, generally, COVID-19 pursuant to a force majeure claim is an arbitrable situation, unless, of course, the subject matter of arbitration under the law governing the contract, the underlying contract is not an arbitrable subject. So for instance, if it's a patent dispute or it's a domestic dispute, but essentially the question here generally to consider is there an FM clause? Does the FM cover a COVID-19 situation? If so, in your particular case, does the occurrence of COVID-19 trigger the FM event? Now, the question in arbitration, again, would be primarily twofold. Again, is there an FM clause? And if so, does it cover a 19 situation, a COVID-19 situation? And two, if there's no FM clause, then what remedies do the parties have under the law governing the contract? But out of experience, and after having considered a plethora of cases, the problem that many parties are likely to face is I understand that the parties frequently adopt more or less standardized boilerplate language as a force majeure act of God clause, instead of tailoring these force majeure provisions to their actual risks. So what many parties are going to find a broad sentence, an unspecific language of force majeure clauses, including catch-all phrases like any other impediment beyond a party's control. And the certainty, therefore, in interpreting what already exists in these contracts will be in a manner consistent with the groups of cases and principles that apply under the force majeure excuse according to the general principles of international law as reflected in under Article 79 of the CISG or Article 7.1.7 of the UNIDROIT principles, which, if you look at the case law that has been generated around the world, it is these two principles that the courts have generally followed while deciding an unambiguous force majeure contention. And of course, mediation is certainly possible should the parties choose to decide that, or if the dispute resolution clause provides for a mediation or a form of mediation, such as amicable discussions and so on and so forth.
Thank you. This leads me immediately to my next question. Sorry.
Just to finish that, you know, in practice, what is going to happen is that if you today have to file a request for the ICC for an arbitration, or you have to assert your claim, step one would be for the party who has received the FM notice or a breach by the non-performing party to initiate arbitration contesting the FM notice and making a case for the breach done by the non-performing parties. Step two would be for the tribunal to look at three core aspects. And I think this is where what the fulcrum of FM clause is going to rest on is three core aspects, which Erdem also mentioned before, is one, it would require the party invoking the clause. I'm sorry, my video is off now, but I hope I'm audible. The tribunal is likely to look at three core aspects, that it would require the party invoking the clause to prove that one, impediment is beyond the party's control. Two, the impediment could not reasonably have been foreseen when the contract was concluded. And three, perhaps very important, the effects of the impediment could not have been avoided or overcome by the party. Now, in the current COVID-19 situation, it may not be surprising that the first two requirements may be less cumbersome to prove. And the case may likely rest on the third aspect, that is, whether the effects of the impediment could not have been avoided or overcome by the party. And this would especially be the case if there is a long-form ICC model FM clause that covers your particular situation, because then the first two requirements would have automatically been met with, and you would only have to prove the third requirement.
Okay. Then we go to the next question, which leads me to cases. Are there any examples of ICC cases where the arbitral tribunal has deliberated or decided on force majeure, on hardship clause, or a related clause? Any experiences here?
The ICC court has had a vast experience in deciding FM clauses. And in particular, I would like to invite everybody who's logged in to look at the ICC Institute's dossier on hardship and force majeure in international commercial contracts. It's a very comprehensive guide which lists hundreds of cases, if not more, on what the tribunals have decided over the last many years, in particularly deciding FM clauses, hardship clauses, and other similar related clauses. I have some examples, and depending upon how much time we have, I'll go through some of them. as to what the tribunals decided. One of my favorite one and a very popular one is the global tungsten case versus Largo Resources. It's an ICC award of 19566 of 2014. I'll briefly give the facts and tell you what exactly the tribunal deliberated upon. Briefly, in this case, the respondent was to supply tungsten concentrate to claimant. It was undisputed that respondent did not deliver the monthly minimum quantities of tungsten concentrate provided for under the agreement. The respondent argued that the agreement should be interpreted as requiring the supply of that tungsten from a particular site, that was Corre Novos, which was the mining site, and relied, among other reasons, on force majeure. Now, respondent's force majeure excuse was based on one of the sections of the agreement, and it argued that its water supplies at the mine site had been depleted because of the unprecedented drought, and as a result of which the operation of the plant was not possible. It contended that since that date, under the agreement, because of the drought, was an act of God, and it couldn't perform its obligations. Now, claimant in this case accepted that in that part of the world, which is the northeastern area of Brazil, it had indeed been affected by drought. But at the same time, claimant contended that respondent cannot rely on the force majeure clause because it did not relieve its obligations because of three primary reasons. And claimant's first reason was that there was no restriction on respondent to supply that particular tungsten from the mine site. It said it could have supplied the tungsten from any other site. On this ground, the tribunal held, after interpreting the agreement, that no, the agreement states that the preamble of the contract provided that respondent must agree and claimant must agree to purchase the material from the mine site. And tribunal could not see how claimant could now claim that respondent must oblige this condition through a different site. The second issue the claimant argued was that the tribunal, that the Largo had other unrelated problems to the drought. That means that even without the drought, respondent could have performed its obligations, and the drought alone is not the only condition because of which the respondent is not being able to perform its obligations. On this issue, the tribunal held that if there are two separate cases or causes, one force majeure and the second some other cause for which the supplier is responsible, then the force majeure event trumps supplier's inability to perform the second cause. The supplier in this case was entitled to rely on the force majeure event to excuse its non-performance, and it did not have to prove that it would have been able to perform had the force majeure event not occurred. The third and the last one, which is I think an important one, is that claimant claimed that Largo had failed to demonstrate that it had insufficient water available to it to enable it to produce the agreed quantities of tungsten. Now on issue 3, the tribunal said that Largo had never asserted at any point in time that it was partially prevented from performing. It had maintained that because of the drought, it was excused from performing in its entirety. In other words, its claim is that drought has totally prevented it from performing the supply obligations under the agreement since that date. And therefore, there was no room in this case for finding a partial prevention. The tribunal actually upheld claimant's claim that on the basis of the evidence and in the absence of any more precise information as the amount to make up water, or as to the date by which new water reticulation system could have been installed or the like, it concluded that respondent had failed to make out its force majeure exposure prior to a certain date. However, it allowed the respondent post a certain date because of other reasons. The tribunal also looked at, and this is going to happen in practice, at the commercial reasonableness for respondents to adopt alternative measures. There are several cases. There's a question of liquidity that I foresee coming in COVID-19 situations. Liquidity issues generally are no ground for an exemption to perform one's duty. Many tribunals have held that. An exemption is only possible if, because of the unforeseeable circumstance, a very extraordinary depreciation of money occurs or the seller's delivery, acquisition, or production cost increase to such an extent that a case of economic impossibility has occurred. And my two favorite cases there are, one is the Tandrin Aviation versus Aero Toy Store. In this case, very briefly, Aero was to buy an executive jet aircraft from Tangerine. After making the initial deposit of $3 million, respondent failed to take respondent failed to take delivery or to make further payments. It relied on an unanticipated, unforeseeable, and sort of a cataclysmic downward spiral of the world's financial market, which according to the respondent fell within the scope of force majeure. The court in that case held that it is well established under English law that a change in economic market circumstances affecting the profitability of a contract or the ease with which the party's obligations can be performed is not regarded as being a force majeure event. In another very interesting ICC case, 18769 of 2014, Cessna versus Gulfjet. Again, this illustrates that principle that an economic downturn may not constitute a force majeure event. In this case, the Gulfjet, a Dubai company, fails to pay amounts due to Cessna for 2 aircraft leases. Gulfjet again relied on the severe economic crisis in Dubai in the Emirates following the world crisis in 2008. It argued that for reasons beyond its control, it became impossible for Gulfjet to operate and exploit the use of those leased Cessna jets solely by reason of economic crisis in the Emirates of Dubai. And the lease was governed by the state of Kansas. The sole arbitrator, the ICC sole arbitrator, rejected Gulf's contentions in that case because the lease provided for a clause that Gulf's jet obligations are absolute and a force majeure event will not absolve respondent of those obligations. But it also went on to hold that even if there was an FM clause contrary to the present situation, the Kansas courts in the United States would not likely have extended the clause to include risks of changing economic and financial markets.
Thank you for sharing these interesting cases with us. It gives a clear picture about previous decisions. What I would like to know now as a last question to you, do you predict that the parties would find amicable solutions for their disputes in this situation? Or would you say that would be litigious in relation to the COVID-19 difficulties? What do you assume?
You know, we at the ICC are actually very eager to see ourselves as to what is going to happen. Until today, as I understand, that we have not directly received any direct COVID-19 related requests for arbitration at the ICC. However, we have received are many queries as to what are the options under the ICC rules of arbitration. When I speak to my other colleagues, I understand that the parties right now are consulting the things that we've discussed above. The lawyers are engaged in giving advice as to their clients if a claim is worth pursuing, if we're told there is a claim in the first place. But it all really depends, and time will tell whether who has a more negotiating power, who has the more money muscle to stagger this claim to the courts or to the ICC, who has the leverage. Companies may come up with an internal policy that they may not want to litigate such claims at all, or they will mediate such claims first, or whether mediation or other amiable talks becomes a go-to option. So the short answer is time will tell. But I will not be surprised that the world will see many COVID-19 related litigation, arbitration, and such disputes around the world in the time to come.
You're surely right with this assumption. I absolutely share it. And before we go now to the questions from our participants, just one short message. We do already have so many questions. Would all the speakers and Thomas agree if we add 5 more minutes?
Yes, of course.
Are you available? Yeah, fine. So we do have many questions coming up. I think Thomas has already done a pre-selection. But what I've seen here in the background that might be interesting for all of you, the one thing is the international trade. The other thing is the payment. And of course, many goods transferred from one country to the other are secured by a letter of credit. And the letter of credits do follow the UCP 600, which are other rules of ICC and also very important rules. And I can tell you frankly that we do have a very practical problem with many letters of credit right now, which is already going on. Yes, the parties have fulfilled their obligations. One party has delivered and has provided documents, but in some countries, it's simply not possible that if you have given the documents under the LC to the bank, that the bank transfers it to the issuing bank. So it's simple, both parties have fulfilled, but the one party doesn't get the money and the other party doesn't get the bill of lading in order to get the goods and the products purchased. So there are a lot of problems coming up, but I think we do have now some questions in the background.
Yeah. So while you look through that, I actually flagged a few of them. So what we'll do is we'll not go chronologically because otherwise we'll never get to the most recent questions. But we'll take some from the recent as well as the beginning of the presentation. So one I have here is from Rajiv, where he says, these suggested force majeure clauses are fine for future. Real issue is about the contracts on hand. What do we do there? It may not be possible to negotiate any clause in the current situation. What do you think about that one?
Perhaps I can reply it.
Okay.
So as I said earlier, everything depends to your contract. So what you have in your contracts, whether do you have a force majeure clause in your contracts, and what this force majeure clause says. So, for example, if you already incorporated 2003 FM clause, ICC FM clause in your contract, the COVID-19 is a listed event as epidemic, and so you can have the right to invoke, provided that you can prove that you cannot overcome the consequences of COVID-19. So everything depends on your contract, really.
Okay. And Angelika, did you have some queued up?
I would add something. This is not a mere legal point of view, but it's practice, which has shown, many projects and many contracts are covered by an insurance. So prior to deciding on what will I do with my partner who can't fulfill his obligations, it might be worth for many participants to this webinar today to check if there is insurance involved, and if they haven't done it yet, to get in contact with their insurance. This is of high importance because you should not only check your contract, you should also check your insurance policy. Is it covered or not? That might be the solution in many cases. Not necessarily for the insurances, but for the contractual parties. Please, Abhinav, you want to add something?
Just to add to that question, see, one would also have to look at, is COVID-19 in itself a force majeure event, or is a government lockdown subsequent to a COVID-19 explosion is what that hindered your ability to perform under the contract? Number one. Number two, you would also look at other definitions that may or may not be available to you under your contract. Are you looking to rely on a force majeure, or are you going to suggest that your contract under the common law definition is frustrated? Now, of course, there is a distinction between force majeure and there's a distinction between frustration. A force majeure is perhaps, if I were to oversimplify it, temporary in nature, short-lived. A frustration, on the other hand, is absolute. The contract ends when it's frustrated. And you have to look, what exactly did the COVID-19 do to you, in particular, in your contract, under your circumstances, given that what your government did when the COVID-19 pandemic took place, since when were you affected? And all these things have to be looked into.
Yes, of course, you're absolutely right, because one part is the contract, and the other part is the implementation of the contract. And there it can be very tricky indeed. Thomas, you give us the next question here.
Sure. So let's see. I had a few here. So we have one from Ariane that says, usually force majeure is underlined by urgency. What are the solutions to get a quick decision where there is an arbitration clause that does not provide an emergency proceedings?
Well, perhaps I could take this one. The parties can always contract into an expedited procedure, if not entirely an emergency arbitration. It would obviously depend upon what rules you're following. For the ICC, if your contract is entered into after 2012, the emergency application, procedure is automatic unless it's excluded specifically under the contract. The parties can, if they wish to settle or to adjudicate the dispute, can shorten the time limit if they choose to. Now, we have the expedited procedure under the ICC rules, wherein all contracts post 2017, 1st of March 2017, undergo through automatic application of the expedited procedure, where the award comes in within 6 months from the date of the case management conference. Is decided by a sole arbitrator. So there are, of course, methods. I understand other institutions also have such tools to do expeditious resolution of disputes.
Yeah. I've seen another interesting question, which is not a mere force majeure question, but it will be the consequence. How do insolvency proceedings influence the contract? And we are all aware of the fact that not all companies will survive this crisis. There will be insolvency proceedings. And what does that mean? I have to say, from my point of view, and I would be happy if you could add here something, Ercument and Abhinav, but if the crisis leads to the fact that a company and a company's existence ends because it's strict, it's so hard for them to continue, then they will start an insolvency proceeding. The first thing why it always starts is usually lack of liquidity, of course. And then it means for the other party, in my view, this is not a real force majeure event, it's an insolvency proceeding. Of course, the force majeure event has led to this solution, but it means you have normal insolvency proceedings with all the hardship. Such a proceeding can mean for the other party a quota of 5 or 10% of your claims. What would you say to that, Abhinav and Ercument?
Angelika, right. So it will be very unlikely that many of the companies or small enterprises may go to the bankruptcy or insolvency after this crisis. It could be a consequence of the current circumstances. However, a force majeure or hardship clause will be triggered only for contractual relations. So even if in the case of insolvency and in the case of bankruptcy, so the party may say, okay, there is an event of force majeure, but it doesn't have any direct impact on the insolvency procedure or bankruptcy procedure.
And I agree. Yes, yeah. I would tend to agree with Ercument. And I think something very important that I should have mentioned in the last question, but allow me to just come back very quickly into it, because this is a question that will come up a lot of time, is that parties can always opt into, whether it's an emergency arbitration procedure or whether it's an expedited procedure arbitration. As long as they wish, they can opt into it regardless of when the contract was entered into. Insofar as the insolvency question is concerned, Angelika, look, again, it will again depend on the problem. The answer is, and I don't want to be a typical lawyer saying it depends for every question, but unfortunately, when it comes to, it is, right? Especially when you bring in the question of insolvency, the world is already dealing with the question of insolvency, and especially in the context of arbitration, which ones happens first and how the law is still developing on that. And I think time will tell how the courts will look at insolvency arisen due to a COVID-19 situation and what impact would it have on the rights and obligations of the parties.
Mm-hmm. Yeah. I've seen another question. Sorry.
Perhaps, Angelika, yes, we have to stress one more thing. So it is generally accepted that the payment obligations under a bilateral contract, let's say for a sale contract, you're going to deliver the goods and the buyer will pay the purchase price. So the payment obligation normally is not subject to hardship or is not subject to force majeure clause. You can always find money to pay your debt. So the only rare case where the payment obligation may be prevented by an impediment is just currency restrictions, currency not available, government restrictions, exchange restrictions, and so on. But even if your company is shut down, you cannot earn money, it doesn't prevent you, unfortunately, to fulfill your payment obligation.
Yeah.
In case you have something, yeah.
Right. Yes, in case you have something.
So we have a forward-looking question from Bersata. So just we're going to go a little bit over, if that's okay, just by a few minutes, because I know we started a few minutes late and we still have a few. We can, Angelika, leave it to you how long you want to keep pushing. But we have a forward-looking question from Bersata that says, can we argue that that past novel viruses such as SARS, swine flu, MERS are sufficient indicators for the foreseeability of such viruses?
Everything is per se, as a legal concept, everything is it's foreseeable. The plague is foreseeable since 13th century, since I don't know, so since the Byzantine time. So there was always plague and epidemic and pandemic, etc. What is important? Can you foresee them at the time of the conclusion of the contract? So let me give you a concrete example. China, everything started sometime in January. So you are dealing with a Chinese company and you conclude a contract. At that time, the COVID-19 existed in China and you have to take into consideration this event. So it was foreseeable for you. This is why what is important is not a foreseeability in general, but a foreseeability at the time of the conclusion of the contract.
Yeah, that makes sense.
Just to add something here, it also depends on the applicable law. And as you mentioned SARS, of course, many Asian countries have been hit by SARS a few years ago, but frankly speaking, in Europe, the awareness of an epidemic like that was not really here. Because they say, yes, there's an epidemic far away. We have read it in the newspaper. We have seen it online and in the news, but there wasn't no awareness at all that something like that could happen. They would say we have vaccinations, etc. And before I logged in today, I looked up the Austrian jurisdiction on epidemic. Do you know what I found out? Nearly nothing, frankly speaking. We have force majeure events, yes, but the last epidemic was in 1918, so more than 100 years.
Yes, probably the Spanish flu.
Exactly. Exactly, the Spanish flu or with any other name. So it is not really an event. I would say you have to take that into consideration. I can't speak for other jurisdictions, but I'm quite sure that under Austrian law, that will not be seen as a foreseeable event. But I would be very interested in hearing what Indian law would provide for that, Abhinav. Could you just give us a short hint?
Sorry, could you just repeat the question, Angelika?
Would you say that an epidemic would have been a foreseeable event like SARS? Under Austrian law, I would say no, but maybe the position in India is completely different.
You know, I would say, yes, I think it's arguable that an epidemic could be a foreseeable event, or it could be an act of God. It could be construed as an act of God under the different jurisprudence that is available. But again, it depends on facts and specific of the particular case. There have been epidemics before, there have been other issues before, and I would not be surprised that, in fact, there is already a Government of India notification on COVID-19, one of the state governments, or is it central government, which lists or considers COVID-19 a force majeure and directs the concerned people to act accordingly. So let's see if other state governments and the courts also look at it similarly. I do want to mention, now that we have the benefit of a lot of people on the seminar, that next week, yesterday in Paris, the ICC court issued a guidance note on COVID-19. It's a very important note. It basically assists the parties, the tribunals, the councils as to what best they can do for the existing and the ongoing cases, as well as to what they might want to consider doing if they want to wish and to file a request for arbitration. And there's a webinar of the ICC court as to what is there in the note for the benefit of the legal fraternity, and that is being done by Anna Sarah Mora, the Deputy Secretary General of the ICC court, and the Secretary General of the ICC court, Alexander Fessis. That's next Wednesday. And I think it'll be a great webinar for existing cases and what the tribunals and the parties can do under the current COVID-19 situation.
Yeah, thank you, Abby, for mentioning that. We put the link in the chat if you want, and we'll share it at the end of this session. Thank you again.
Okay. I think I don't see so many questions coming up right now. If you agree, I would say we will finalize this session today. It was a pleasure to be here with you, even with a great distance, I have to confess. And I'm quite afraid our next personal contact will take some time. I'm not too optimistic that traveling will be an option during the next weeks, but I'm optimistic for the future. And it's a pleasure for me to give a kind of a conclusion for this session right now. And that's, I think, the outcome of today's concerning force majeure. There is no general rule. There is no one-fits-all solution. You have to go to your contract. You have to check your force majeure clause and what it says in detail. Is it a mutual clause or is it just one-sided? I have seen both. Yeah, you have to check it. And in case your contract doesn't provide a force majeure or hardship clause, you have to check the applicable law, and you have to check previous cases, which could be compared with the situation right now if you find something like that. But what you should bear in mind, and what we should all learn for the future, is from this situation, we have to protect ourselves in the contract. We have to protect our clients if we act as lawyers, and advise them to say, you can't foresee everything. A force majeure clause and a hardship clause could make a lot of sense. And please allow me a last comment before I say goodbye. And I would like to take this opportunity to thank Abhinav and Ercument for their excellent presentation, and you, Thomas, for the technical support, because obviously legal issues I can handle, but with technical issues, Thomas is the expert. Thank you so much. I think the last conclusion for this force majeure clause should be protect yourself, protect your clients, and as protect yourself means the same for all of us, I say goodbye with a protection.
Thank you so much, Angelika. Thank you again for the speakers and for everyone for your time. So as a reminder, we are hosting live broadcasts on this topic in addition to other trade topics like the Incoterms rules, cryptocurrency, leadership coaching, and many others. And as mentioned, we also have a similar session planned for next Wednesday, which we recommend that you sign up for. It is free. So sign up on our website and subscribe to our YouTube channel. We will be posting this as a recorded video in a few days' time. So thank you again, ladies and gentlemen.
Thank you.
This has been the second episode of the COVID-19 briefing, and see you next time.